My name is Sofia Romero, and I am a senior staff attorney here at ACLU of Nevada.
My name is Alex Falconi. I am a software engineer. I created the Our Nevada Judges organization, which includes camera access to courtroom proceedings, statistical analysis on judicial error rates, and we, for the most part, track every single judge and courthouse in this state. What made me want to create it was very personal. It was the inspiration that I got from the Supreme Court when they intervened in my own specific child custody case. I started to see that it was bigger than just pointing out how often judges make mistakes. It was more important to see if there was a way to bridge the gap between the judiciary and the public. They can see and hear for themselves how the courts are operating, where they can base what they feel on their actual observations.
ACLU of Nevada was approached by our Nevada judges, letting us know that the court rules in family court were changing. All court hearings were going to be held privately rather than publicly. We discovered two rules that we felt were unconstitutional. The first rule says any party or the court itself can request a hearing to be sealed or a case to be sealed. The papers would not have public access, and any hearings or trials would not be able to be attended by the public. Access to the courts is one of our fundamental First Amendment rights. The second rule declares any type of custody matter a paternity matter, whether or not paternity is actually in question. Paternity matters have been sealed in Nevada since 1979. So now, whether or not parentage is actually in question, that matter is going to be automatically sealed.
I was dismayed when those rules came about because I knew immediately that they were going to be used to basically block all access to family court, at least in the manner in which they were written. There are some people who would think that our Nevada judges exist to scrutinize the judges, and really it's not. But as I was covering cases, I started to stumble into situations where I noticed, we'll just use the word alleged abuser, was actually benefiting enormously from their ability to seal and redact and close hearings in the family court case. When you talk about domestic violence, it hits home to a lot of people. When we only allow the public to observe these cases after they get so bad that they spill into criminal court, we're really doing a disservice, in my opinion, to the public. It's kind of just leaving this big blind spot. We should get into the family court because that's where you're going to get to the root of a lot of these domestic violence issues. And also because the confidentiality and the sealing and redaction appears to be doing a lot more good to the alleged abuser than it's actually doing to the victim.
We want survivors of abuse to be able to have a support system there with them in the court. And we worry that with these privacy rules, abusers may take advantage of this and try to intimidate survivors into not having any type of support system there with them. Both of these rules are unconstitutional on their face because they don't balance the First Amendment interests with any type of privacy interests of the party. To stay updated on this case, you can visit us at www.aclunv.org, or you can stay updated on any of our social media platforms at ACLUNV.